నమస్తే. తెలుగు ప్రజల మన సాక్షి టీవీ. I am Swarna. Welcome to Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from the Law Office of Prashanthi Reddy PLLC. Please note down that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST time with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. with attorney Ms. Prashanthi Reddy, and on Friday at 6 p.m. EST time with Banu Ilindar. Please tune in to ask for questions. If you have any queries regarding immigration, please feel free to call us. Our attorney would like to answer your questions. If you are immigration attorney and would like to join in our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note down the information provided in this show is not legal advice. It's for general information purposes only. Sakshi TV or its agents are not responsible for the use of this information. If you need a special advice, please contact our attorney directly. Today, we are going to talk about I-485 H1 EAD immigration update. We have attorney Prashanthi Reddy Garu with us. Without any further delay, let's start our show by welcoming Prashanthi Reddy. Hi, Ms. Prashanthi Reddy. How are you? Welcome to the show.
I'm good, Swarna. How are you?
I'm good, thank you. So, Ms. Prashanthi, please provide information about your law office, law practice area, and your experience.
So, yes, my law firm is Law Offices of Prashanthi Reddy, located in New York City, close to Penn Station. I've been practicing for 20 plus years now, and if anyone needs to reach me, they can at my email is the best way to reach me, prashanthi@reddyesq.com.
Okay, so viewers, if you have any questions and would like to reach out to Prashanthi Reddy Garu directly, our number is 212-354-1010, extension is 107, and email ID is prashanthi@reddysq.com. So, Ms. Prashanthi, please comment on upgrading and downgrading of I-140. What are your thoughts on this? Should it be done?
Definitely the upgrading and downgrading is continued to be done, and especially because it's unknown as to what will happen in the future. People are anxious to, upgrade to EB2 or downgrade to EB3. Going a step back, a lot of viewers may not understand the question we are asking also as to what is upgrading, what is downgrading, what is EB2, what is EB3, what is I-140. So we're presuming, of course, most will understand the basic terminology that we're using. But for those who don't, so the second stage in a green card, there are 3 stages altogether. First is the labor cert, where the labor market is tested, and if there's no US citizens, permanent residents available for the job, then the labor gets approved. Then the next step is with USCIS, which is the I-140. And in the I-140 stage, there are many different categories of jobs. And based on the categories, the time taken to get the green card varies. So in the second stage, it's an I-140 stage. And in that stage, you decide, you have to mark the category that you want to file in. So for example, if you qualify for EB2, you can mark the EB2 category in the form, or you can ask for EB3 also. Because EB3 is a lower category. But if you qualify for EB3 to start off with, meaning that you don't have an advanced degree or you did not ask for an advanced degree for the job, then you can only qualify under EB3. But if you have asked for an advanced degree in your job, in the labor cert, and that's how the advertisements were placed, then you can decide whether you want to file under the employment-based second category for advanced degree holders or the employment-based third category. Overqualifying is not a problem. You cannot underqualify. So having said that, people obviously want to choose the highest category that they qualify for, and a lot of Indian nationals have master's degrees or more than 5 years of experience, so they can qualify as an advanced degree. So most of them file for EB2, and because of that phenomenon, we have found that EB2 is more backlogged than EB3. So EB3 is moving faster and EB2 is slower compared to EB3. This is with reference to the priority dates. So as I said, there are 3 steps in a green card, second being the I-140, where we choose the employment basis, and the third is the 485, adjustment of status. So in order for the 485 to be filed, there is something called a priority date. The priority date is the date that your labor cert is filed, the first step. So that's the priority date. So the EB2 priority date is different, the EB3 priority date is different, EB1 is different. So the priority dates are published every month in something called a visa bulletin on the travel.gov website. Based on that priority date, if your date is current, then you can file the next step, which is the 485. So now we have noticed that the priority dates are moving faster for EB3 versus EB2. So a lot of people are who have already gotten approval on the I-140 are now refiling the I-140 after several years under the EB3 category. As I said, you can choose to file to downgrade to EB3 if you qualify for an EB2, because downgrading is not a problem. Upgrading is a problem, because to upgrade you can't just then refile the I-140, you have to refile the labor cert itself. So that's a longer process, because the labor cert can take 6 to 8 months to a year to get approved, and then the I-140 takes a few months even if you do premium processing. As I said, a lot of people are downgrading from EB2 to EB3. And there are questions as to what happens to my previous I-140 EB2 category if I downgrade. Is it still alive, or does it get cancelled out? Does it automatically become void? So these are the questions, common questions that people ask and should know the answers to before they decide whether they want to downgrade or not. So to answer that question, if you're downgrading and you're applying for an amended petition, then you have a problem, because you're amending the existing petition, which is EB2 to EB3. And the problem is that if EB2 were to then become current, you then have to again file a new I-140. So you don't want to amend at any given point of time when you're downgrading. You want to file a new petition. So when you file a new petition, what happens is the previous EB2 I-140 remains intact as it is, and you get an approval on you have 2 I-140 approvals now. So you get an approval for EB3. So you have EB2 and EB3. So you can choose which one you want to use depending on the circumstances and depending on the priority dates. You can file the 485 based on EB3 now, because EB3 dates are better. And later on, if EB2 final action dates become current, you can always request USCIS to interfile. Meaning, you send them the EB2 I-140 approval and you say, I want to use this approval against my pending 485. So they will use the I-140, that is, as long as you're still working for that employer and the job offer is still open, they will use the I-140 which has the best priority date, pretty much. So that is, one of the nuances of downgrading from EB2 to EB3. Make sure that it's done as a new petition and not as an amendment. The second point to remember is that when you're filing an I-140 downgrade, it's not necessary that it will get approved. So keep that in mind. Every petition has a life of its own, so it may or may not get approved. You might think that my previous petition got approved, therefore this one has to, but there are things that change. If you're filing several years later, the employer might have a different financial scenario. So one of the most important things is in an I-140, other than the beneficiary's qualifications which don't change, on the basis of which you will not again get a denial if the case was previously approved, are the finances of the company, whether they have the ability to pay your prevailing wage approved under your labor cert or not. So the ability to pay depends on how much you are getting paid, and also depends on the tax returns of your company. So that if you're not getting paid the prevailing wage, but the tax returns show a good profit, or they show a good net current assets that you can look at in Schedule L of the tax returns, then your case can still get approved. But as we know, finances of a company never remain the same, and it changes from year to year. So it could be that the year that you're filing now, your company is actually running at a loss. Or it could be that they declared a loss. There are a lot of companies that don't want to show a profit, so they use whatever loopholes they have, in the IRS regulations to, show deductions and expenses, and then they show a loss. So whatever the actual picture might be, if the tax returns show a loss, then, and if you're not making, your W-2 doesn't show the prevailing wage, then it'll get denied. So just be careful while filing the I-140. It doesn't mean that it will get approved. And the other problem is that if it gets denied for a reason that was overlooked when the first I-140 was filed, it's possible that they might send a notice of intent to revoke on the first I-140 also. So just be careful if you have a case that is questionable or borderline. You may not want to take that chance of downgrading. So that's something to keep in mind. But otherwise, in general, downgrading is not a bad idea. Premium processing can be done, but depends on the office where it's being filed and the circumstances. Some offices are accepting, some cases they're accepting, some cases they're not, depending on whether they have the original labor cert in that office or not. So that's another thing. Premium processing is another point to remember that can make a difference in whether you want to file or not. Because, for example, if your priority date is going to become current very soon, then you might want to do premium. If you cannot, you might want to rethink whether you want to, file the downgrade itself, because the purpose of the downgrade will then be lost. But of course, we can also file, another thing to keep in mind is if premium processing is not available, we can also file the I-140 and 485 concurrently. So you can file the I-140 downgrade petition and file the adjustment of status together. So that's one way we can overcome that premium processing issue. You don't have to wait for the I-140 to get approved, the downgrade to get approved, to file the 485 in case, it's already current. You can do both together. But the disadvantage of that is if the I-140 gets denied because of ability to pay or other issues, then you lose all the money that you paid for the 485, which is quite a lot, $4,000-$5,000 or more. So those are some of the advantages and disadvantages or characteristics of, downgrading from EB2 to EB3.
Okay, Ms. Prashanthi, before we go to the next question, we have a caller, Pavan from California.
Hey,
hello.
Can you hear me?
Yeah. Please go ahead.
Okay, thank you. I have a quick question. Actually, my nephew attended the student visa interview in India, and they gave him a 221G. I know 221G give for any missing documents and whatnot, but they give a denial on the presidential proclamation 10199, and they denied it. So the question here is it a real denial, or we still have any opportunity or anything that we can work with the U.S. immigration to process that particular application?
So actually they should not be denying it on that basis, on presidential proclamation, because the travel ban, COVID-19 travel ban is, there's an exception for students. And you don't have to show any other qualifications for that exception other than the fact that, you are coming to the US to attend school on a student status. So I'm surprised that they denied it based on that. Definitely something to look into. You should contact the consulate and send them the law, if that is correct what you're saying, and if there is no miscommunication in information. But in general, administrative processing is denial, meaning that they're saying that we deny your case now, But if you send us blah, blah, blah documentation, then we will take a look at it. So that's what the meaning of administrative processing is. They're further investigating your case. They're not approving it on the spot. And usually that could be, that information that they're requesting could be anything. In a student status, it could be intent, whether they have the intent to return to their country or not. It could be sometimes the bona fide, as to whether the university is a bona fide university or not. Usually it's intent. Usually they don't believe that, the person will come back, and it's an arbitrary kind of subjective analysis. But they do look and see what the circumstances are. If the student has enough money to pay the tuition, if he has enough reasons, ties to the home country to go back to the home country. So but you're saying it's based on the proclamation, then you should definitely send them an email that students are exempt from the proclamation. Is he still there? I guess his question is answered.
We can go with our next question. So, Ms. Prashanthi, how will filing an I-485 application be beneficial to someone?
How will filing a 485 benefit? I'm sorry, you got cut off there.
Yeah. How will it will be like filing for I-485 application beneficial for someone?
Or benefit someone, okay. So yeah, there's a lot of benefits by filing a 485. The first and most important benefit is you have flexibility of changing your employer. So every time you change your employer, you do not have to go through the rigorous process of filing a transfer, which you would if you were on a H1. If you're on an L1, you can't even transfer your company unless you go back, leave the country, work for that other company for a year, and then come back again on an L1 through the new company. There's no such thing as transfer for an L1. For a H1, there is a transfer process, but it is a rather tedious process. And sometimes cases can get rejected, they can get denied, and you then might fall out of status if you've already started working for that new company, or if the old company has withdrawn the H1. So being on a H1 or L1 or other non-immigrant status is fraught with problems always, and there's always a chance of going out of status whenever you file something with USCIS. So that's not the case with the 485, because when you file a 485, after the I-140 is approved and after 6 months of filing the 485, you're allowed to transfer employers. You're allowed to move employers and have a new sponsor. And there's a very simple form that you have to, and that you have to send out, a 485J. And the requirements for that form are also not very tedious. It says, you have to be working in a similar job, not the same job, but a similar job. And, if you're in that profession, most probably you will be working in a similar job. You're not going to be working as a financial analyst if you're a software engineer, right? You will be most probably working in that software field. So that's an easy requirement to meet, and 99.9% of the people meet it. So the advantage of course, flexibility where employers are concerned, and you can do this multiple times until your green card gets approved. There's no fixed number of times that you can do it. It's unlimited number of times. You can keep changing employers. So definitely that job flexibility is a huge blessing for people to get promotions and to go up to further their career. Also, every time something changes in your job, for example, if the job location changes, for a H1 you have to file an amendment. And every time you file an amendment, again, it's possible that you might lose your status, because every time you file something with USCIS, it's always a question mark whether it'll get approved or not. So there's always a chance of, losing status. In a 485, if you're on a green card, as long as it's a similar job, even if the location changes, provided you're working in an IT company and you have filed the labor that way, as multiple locations, it doesn't really affect your 485 filing. You don't have to send anything to USCIS or inform them. that the location has changed, the client has changed. So that's another big advantage. Third is, you get something called the EAD, the Employment Authorization Document, and you get advance parole. Now, employment authorization allows you to work, and it works for multiple employers. On a H1, you can only work for that one H1 employer. On the EAD, you can work for your employer that's sponsoring your green card, and you can do an additional job as well, part-time job. And nobody will question you. You don't have to qualify for that job. As in, for a H1, it has to be a specialty occupation. You can't work in a gas station, as a part-time job on the weekend. But on an EAD, you can. As long as you're working full-time for your sponsor, in addition, on the weekends, you want to do something, go ahead. You can teach, you can work in a gas station, you can do anything. Work in a store. That's the magic of the EAD. There's, flexibility. There's no rigorous conditions imposed to it. The other thing is sorry.
We have a caller.
Sure.
Hi, Mr. Lee, how are you?
Hey, hello, ma'am. Good evening.
Good evening.
Ma'am, my question is, on last October, I have filed for my adjustment of status. I am on L1A, E1, EB1C quota. In fact, my priority date is 2019 December. If I request for the expedite for 485, will it be any problem?
There's no problem. You can do a service request and ask for 485 to be expedited since your visa number is available. But they may not expedite it. They may or may not, who knows. But you have to give good reason. You can't just say that my visa number is available, therefore I need you to expedite it. So you have to give a good reason as to why you want it to be expedited. And there are certain criteria now that they have, in a recent memo, they have spelled out the criteria for which case qualifies for expedite and which doesn't. So, if you meet, there is no harm in requesting it. That's the bottom line.
Oh,
You're just, it's just
kind of a genuine case. The reason being there are some incidents happening in India. Being EAD and advance parole may not be possible for me to come back to US, so I have to depend on the green card. So that's why I thought I can try out because I have the evidence, documents, everything ready. If at all they agree, probably I can showcase that one. So the question is, it is possible, right, ma'am? Nothing wrong in request, right?
That is correct. It doesn't harm your case in any way.
Okay, that's great. Thank you so much for your answer.
You're welcome. Take care.
Thank you. So, viewers, if you have any questions and would like to refer to Prashanthi directly, the number is 212-354-1010, extension 107. And you can email her by prashanthi@reddysq.com. Right. So, Ms. Prashanthi, must a non-citizen be in a non-immigrant status in order to be eligible to file a I-485?
So, Swarna, we were still talking about the advantages and disadvantages of filing the 485. We haven't finished that, so I wanted to add another point, which was the advantage of having advance parole. So, in addition to EAD, you also get something called advance parole. And the advance parole is really handy because you don't have to go to the consulate to get a visa. You can travel without a visa. And if you're dependent on a visa, it is really dangerous because when you travel and if you do not, the visa does not get approved, like the previous caller had, the F1 visa got denied. There are even worse situations where people are on H1 for years and then they go out of the country to get a visa extension and it gets denied. And, they've been in the country for several years and they have a car, they have a house, they have assets, they have a life in the US and they suddenly cannot come back. So that is a big relief when you file the 485 because you don't have to worry about a visa approval at the consulate. You can travel using that advance parole card. The only thing is for the EAD and the advance parole, you have to apply for it. So, and the good thing, again, as per the latest update from USCIS, is that they're now giving it for 2 years. So you don't have to keep applying every year So that's also a relief that you can apply every 2 years for the advanced parole and for the EAD. So that's good news as well.
Okay, thank you, Ms. So, can we go to the next question?
Yeah, go ahead.
So, must a non-citizen be in a non-immigrant status in order to be eligible to file a I-482?
So your question again, you're cutting off, Swarna. You're going in and out. So I can't hear you properly, but I'm going to guess the question. I think you're asking me, does the person have to be in status in order to file the 485, right?
Yes. Yes.
Okay. So, yes, in general, the person has to be in status in order for you to file the 485, unless it's a marriage-based case or it's an immediate relative. So, son, daughter, parent of US citizen, husband, wife, US citizen. They can file a 485 even if they're out of status. That's the exception to the rule. But in general, and since we're talking about employment-based 485s, yes, you have to be in status in order to file. But there are some exceptions to that rule. USCIS has, in order to make life easier, put some exceptions in the rule. One is that under 245K, regularly under the Immigration and Nationality Act, if you are out of status for less than 6 months, before filing of the 485, a total of 6 months. It could be at any given time. If it's less than 6 months, then you can still get the benefit of filing the 485 and getting it approved as well. So that's something to remember. And the second thing to remember is that they will only look at your status from the date of your last arrival. So you might have been in the US for 10 years. You might have been out of status during that time, 6 years ago. But they will only look at 6 months ago, since your last travel was 6 months ago. So from the time that you traveled and came back into the country, which was 6 months ago, to now, they're only going to look at that period of time, whether you maintained your status or not. So that's a much, much easier thing to maintain status during that short period of time. So for example, just to give you an example, if the person is, say, on a H1, but lost his job, say 8 months ago, right? So can he then, suppose he gets back his job or he gets a new job, and he has a labor and I-140 approved, or a labor approved at least, can he then file a 485 directly? Even though, he has no status because he lost his job. So you have to remember 8 months ago, so once the person gets laid off, he has 60 days grace period. So to find another job, so that is not counted as out of status period. So that 60 days, so that's 2 months, plus the 6 months covered under 245K. So that's 8 months. So up to 8 months can be forgiven for a person who's on a H1 status, if they were out of status, if it is due to losing job. So getting laid off or whatever the reason might be. So a person in that situation could file a 485. So there are always some exceptions, but in general, the rule is that you have to have a valid I-94 before you can file a 485.
So, what if there are in violation of their? Oh, Ms. Prashanthi, we have a caller, Nagesh. Hi, Mr. Nagesh, please go ahead.
Hello, ma'am.
Hi.
Yeah, hi. I have a question. Actually, I filed my adjustment of status in October, and I got my EAD, and my wife got the EAD. I did a downgrade. My priority date is August 1st, 2011. So when do you think, I can get my GC? Or is there any, so I should be current in EB2 also probably next month because it is August 2011. So I just wanted to see, when can they adjudicate my case?
So I can't tell you exactly when they will adjudicate because that no one can tell you, but I can explain the process to you so you understand what the steps involved are. If you're once your date becomes current, they have to look and see if your file is complete or not, right? So if your file is complete and they are not going to send you an RFE, for example, they can usually sending RFEs for medicals if you have not sent medicals in the initial stage,
Yeah,
or if there's
I'm
some
downgraded
deficiency,
already, actually.
right? Or if there's
So
some
yeah,
deficiency
I
with
did
your birth
medical.
certificate,
Okay.
something which you may not know sometimes. So if there is no deficiency in your case and if it is complete, then once your visa number becomes available and once an officer starts looking into your case and processes it and finds that it's complete, they will reserve a visa number for you. That's when your visa number is reserved and you can be assured of getting the green card. But in the preliminary, during that time, suppose they do send an RFE for some reason, and you take time to respond to that RFE, or for some reason it's not enough time, so by next month the priority date again retrogresses, then you're out of luck, because the officer will not reserve the visa number until the file is complete. So if there's an RFE for some reason, that will delay your case. Having said that, final action dates are not likely to retrogress until sometime next year. So if your date becomes current next month, and it's an if, we don't know for sure, right? Then you can expect that in the next few months, your case should be processed because it's already pending since October. And if there's nothing required, then you should get your green card soon. So let's hope that's what happens, provided, of course, there are not a lot of ifs, but all those conditions are fulfilled, then you should get it.
All right. Thank you. All right, Ms. Prashanthi. So coming to the next question, we have we need to know a lot of things. You are really helping us. So Ms. Prashanthi, what if they are in a violation of their H-1B status since their last entry because their employer terminated them as a result of the COVID-19 economic downturn 120 days ago, but now wishes to hire them back? So what should be?
Yeah, so this, I actually already jumped that question. I used it as an example, right, in my previous explanation. So yeah, if they have been laid off, and if it's less than 6 months, or if it's 6 months plus that 60 days grace period, then they can still file the 485, as I was explaining earlier. So under those limited circumstances, they can still file.
So what if the final action date on a non-citizen's prior EB2 I140 becomes current because the final action date on their EB3 becomes current?
Again, I can't, for some reason today your audio is going in and out, so I can hear some things and I cannot hear. Sorry. So I think what you're asking is, can you repeat the question again? Are you saying that? Yeah, go ahead.
What if the final action date on non-citizens prior EB2 I140 becomes current before the final action date on their EB3 becomes current?
Oh, okay, got you. So, so this is a scenario in which they either had an EB3 I140 or they downgraded, as a previous gentleman was mentioning that he downgraded, and they filed a 485 based on that, because the dates for filing in October for EB3 were much ahead of EB2. So a lot of people downgraded so that they can at least file their 485. Dates for filing allows you to file. There are two dates in the visa bulletin. One is dates for filing, which allows you to file in advance, and the other one is final action date, which where you can file and your case will also get approved. So in this scenario, and it's happening with a lot of people now because EB2 is moving quickly, and there is promise that it will move forward much more rapidly in the next few months until the next fiscal year, until October. They're expecting rapid forward movement. So it might be that you downgraded to EB3, and if you filed a new petition, as I was explaining earlier, and not an amendment, then your EB2 I140 is still alive and well, and all you need to do then is, if the EB2 final action date has become current, obviously then you want to use that EB2, not the EB3, because dates for filing, you don't know when they'll become current. So then you have to ask for USCIS, open a service request, ask USCIS to use the priority date, the I-140 for the EB2 case, and process your 485. It's called interfiling. There's no form to be sent as such, so there's no fee to be paid. So sometimes getting this done can be painful because there's no receipt. So it's hard to track your request. But in general, you should send a written request asking for interfiling of the EB2 I-140 towards your 485. And you can also follow that up with a service request. And it's possible to track the service request. So at least that gives you, because they give you a number, a receipt number for the service request. So you can at least track what happened, to your request. And usually they say it takes 60 days, but it may be sooner. So that's one thing you can do. In case the EB2 final action date becomes current and you filed under your EB3 I-140.
So viewers, if you have any questions and would like to reach out to Ms. Prashanthi directly, you can reach her at 212-354-1010, extension is 107, and her email address is prashanthi@reddysq.com. So, Ms. Prashanthi, like you explained, if you have a non-citizen as a child who is 18, will the child age be protected under the Child Status Protection Act if the child turns 21? And I-485 applications are still pending?
So that depends. With USCIS and immigration law, I always have to say it depends, because there's never a straight answer. So under CSPA, if first of all, putting CSPA aside, if you file a 485, that automatically stops the clock on the age, but that happens only if you are filing the 485 based on the final action date. Remember, I said there were two dates for filing and final action date. If you are filing your 485, or your 485 is being processed based on the priority date in an I-140, based on a final action date in the calendar, in the visa bulletin, then the clock stops. So you don't have to worry, even if it takes 5 years for the 485 to get approved, as long as the dependent filed before he turned 21. Once he files, even if he turns 21, it doesn't matter. But that applies only if you have filed under final action date. A lot of people in last October filed under dates for filing. In that instance, the person does age out. If the 485 continues to be pending, which most probably it will, because it will continue until the final action date becomes current, right? It has to be, your priority date has to be current as per final action date in order for them to process it. Otherwise, the 485s remain pending for years together. And during that time, if your child ages out, then you're out of luck. So you need to make sure that you shift that child to another status before they fall out of status. That's why in a lot of instances, people are maintaining their H1s and their 485 simultaneously, so that the child doesn't suddenly fall out of status. The child remains at least on a H4 and can then file a change of status to an F1, even if the 485 gets denied. So if the child is not on a H4 and is simply on a 485 status, then once he turns 21, he simply falls out of status because the 485 gets denied. And then you cannot change status in the country. You have to leave the country. Apply for an F1 visa outside the country. If you get rejected, then you cannot come back in. But if you remain on a H4, then you can file a change of status cleanly within the US from H4 to an F1. And that's why a lot of people are maintaining their H status also. And there's a limited benefit under CSPA, Child Citizenship Protection Act, where they say that the time taken for the immigrant petition to be approved, the processing time for the immigrant petition, which is the I-140 in this case, So for example, if the I-140 took 6 months to get approved, then they'll deduct that 6 months from the age of the child. So say the child is 21 years and 6 months old, or 7 months or whatever. If they deduct that 6 months and he then becomes under 21, right? He becomes 20 and whatever, 11 months, then he is still eligible to file a 485. As long as you're filing under final action dates, of course. So that's the benefit of CSPA. It's a limited benefit, but it's useful especially in family-based cases because I-130s, which is the immigrant petition in that instance, take many years sometimes to get approved.
So, should one request premium processing on the downgrade of I-140 petition?
One should, if they have the money, but will that get approved or not is a different question, right? That's a $1 million question that we kind of alluded to earlier. So when you downgrade it, I mean, of course you should have asked for premium processing. Why wouldn't you? Some people think there's a disadvantage of premium processing, that there's more scrutiny if you premium process. I don't believe that. The only thing with reference to premium processing is always the premium processing unit are usually senior attorneys. So they don't have entry-level people doing premium processing cases usually. That's what, I found out once when we went to the Vermont Service Center on a visit. That's what they told us. So because they need to be processed quickly, and it makes sense also because they need to be processed quickly, they need a senior level person who knows the ins and in and out of the law, and they can look at the case quickly and make a decision and doesn't have to research or ask anyone else what the law is. So obviously it's quicker if someone senior level person does it. So having said that, so then you can expect then that there'll be less silly mistakes, that there'll be less RFEs, mistaken RFEs sent. So in that way, it's good. So some people think that there's more scrutiny. I don't think there's more scrutiny. I think things get done faster when you do premium processing. So the only disadvantage is the money. And with reference to premium processing, if your employer doesn't want to pay, that is another disadvantage. You can pay the premium processing fee as well, where the 485s are concerned. I-140s, the premium processing part can be paid by the employee as well. So there is no disadvantage as such, only an advantage. But whether USCIS will actually accept a case under premium processing, USCIS has always said that if the original labor cert is not in their office, then they will not. Then that labor cert has to be requested from the Labor Department, and therefore they cannot accept premium processing because they cannot get that labor cert within that 30 days, right? Because they have to process 30 days premium processing, otherwise they have to refund the money. That's what premium processing is. But in many instances, in these downgraded cases, these cases are often filed at the same service center. So theoretically, they should have the labor with them because the initial I-140 was filed in their office. But somehow, even in those cases, they don't seem to be having the labor. Maybe they sent it to a different office. So because they don't have the original labor, they are refusing to process premium. And in some instances, they're just sending it back. In some instances, they are sending instructions to refile in a month because they are saying that they will request for the labor cert and it should take about a month, or they're giving us certain time, and they're saying refile after that particular period of time. So, and in some instances, they're just saying we don't have the file, sorry, we can't premium process it. In which case, then we're just waiting for a month or two and then resending the premium processing. It's not clear as to when you file a premium processing, especially in a downgraded case, whether it will be accepted or not. But there's no harm in trying. And if it gets sent back, to wait for some time and resend it again.
So viewers, if you have any more questions and would like to reach out to Prashanthi, you can call her at 212-354-1010. Extension is 107. And you can email her at prashanthi@reddysp.com. So Ms. Prashanthi, a non-citizen has an approved EB3 I-140 filed by a prior employer. Their employer has filed a labor certification and wanted to capture the prior date of the prior I-140. After the labor certification get approved, then the prior I-140 can be used to file an I-485 application.
So the facts are a little unclear, but so is the question that the I-140 was filed, but the person is no longer working with that employer?
Yeah, he's no longer working with them.
Okay. So if the person is sorry, today I can't hear you. That's why I'm asking you again. The question is sorry about that. If the I-140 was approved from a previous employer, but you, I guess, left that employer maybe a month ago, 6 months ago, whatever it is, and you filed, you joined the new employer has filed a labor cert for you, but it takes time, 6 to 8 months for the labor cert to be approved. So if your priority date is becoming current now, then obviously you don't have the luxury of waiting for that new labor cert to get approved, because it has to be approved before you can file even if you want to file I-140 and 485 concurrently, before you can file the I-140, labor has to get approved. So in this instances, many people are trying to go back to their old employers and then file the I-140 and 485 through them. In some instances, they are keeping the job with a new employer, but just filing the 485 with the old employer as a future job offer. In that situation, I would say be careful, because intent is important. So USCIS might question that you don't have the intent or the job, there is no actual job offer for you at the old employer because it was there previously and now it's not there. The person has laid you off or you have left. So obviously very recently that happened. So that job doesn't exist for you anymore. So suddenly, how did the job open up? Simply because the priority date became available, job opened up for you. So they're going to question that as to whether the job actually exists or they're just filing it for the sake of getting the green card. Very important to keep that in mind. But it could be that you actually go back and start working for that employer, transfer your H1 to that employer, he gives you an offer letter, puts you on his payroll, and then you start, then you file the 485. That is a better scenario, at least, because you're showing that you already started working. And so if someone questions, you can say, what do you mean, does the job offer exist? It already exists, I'm already working. So you have a much better chance of explaining things there. I would prefer the second scenario if you're going to go with your ex-employer. Join them, get the offer letter, get on the payroll, and then file the 485 instead of doing it as a future job offer. So absolutely you can do both ways, but as I said, I think the second way would be preferable from the USCIS point of view.
Ms. Prashanthi, we have a caller, Mr. Shekhar from Texas.
Hi, Prashanthi.
Hi.
Hey, thanks for time and helping us, answering your questions.
You're welcome.
So you were the one who filed for my labor. And,
okay. You should have just called me then.
Okay. So
I'm always open for my old clients and my ex-clients, always welcome to call.
Yeah, I do. Still remember we have a conversation with you. In 2014 and 15. So thanks, Prashanthi. Helping our community and everyone, right? So I have a question about my PD date is 2015 November. So do you want to suggest for downgrade or no? For the EB2 to EB3.
EB2 or EB3?
Mine is EB2. So I'm thinking of one, maybe the filing date will go to 2015 end. So if I do not downgrade now, so I may lose the boat, to
have a
No, you won't. You won't necessarily lose the board because, as I was saying earlier, that you can file the downgrade and the 485 together, right? So what's stopping you from doing that? Why? I mean, as I said, doing a downgrade is not necessarily always safe, right? There could be issues that come up again. So unless you need to, why should you file the downgrade? If your date becomes current, then you can file the downgrade and the 485 together. Just something to think about. You can file it now also, nothing is stopping you from filing it. And you can do premium processing, and as long as you do it as a new petition, as opposed to an amended petition, you want to keep it ready, that's fine. But just keep in mind that whenever you file something, and if it's not needed, and if something comes up in the case which might affect your EB3 I140 also, that's something you want to avoid. So only do what is needed. Never go to USCIS unless you absolutely have to. Never file anything with them unless you absolutely have to. Because you're simply opening yourself up to liability. And I don't see any problem in filing an I-140 and 485 together. The only disadvantage is not filing them separately is when you file together, then you lose the 485 fee, right? That's the disadvantage. If it gets denied. If it doesn't, a lot of people have filed, 70, 80, 90% of the cases usually get approved. So I would say go do it when your date becomes current. But do all the paperwork now, do all your homework now, talk to your employer, make sure they're okay downgrading, do all that now because it's likely that it will get current in October. They're saying, some people are saying 2016. Hard to tell, but yeah, it's possible that it might become current.
Okay, so we can go ahead with our next caller. We have Mr. Murali from Boston.
Yeah, hi. Hi, I have a question for the business visas. Do you know when it's going to release the travel restrictions from India for the parents?
Well, if you can tell me when COVID is going to go away, then I can tell you when the travel restrictions are released. I know everyone. Yeah, I mean, you knew I would answer it this way because you know yourself that it's difficult to tell when COVID restrictions are going to be removed. But as of now, we have not received any indication that the restrictions are going to be removed. But we're hoping if the downtrend continues, in the COVID cases and more people get vaccinated in India, that they might remove it after the summer. Who knows? I'm just guessing. But I'm hoping that things will normalize, in the fall or at least by the end of the year. Let's see what happens.
Thank you. So, Ms. Prashanthi, so you think EB3 I140 downgraded be denied?
Yeah, it's possible that EB3 can get denied because, as I said, finances of the company never remain the same. And your salary also never remains the same. I mean, usually you expect salary to go up, but with COVID and everything, people have had to take a pay cut and accept jobs with lower salaries. That's also a fact. So because of that, that is the only thing that usually changes. Your degree remains the same, your qualifications remain the same. Unless, as I said, something was missed out previously, they didn't notice something. For example, they didn't notice that your degree is not from an accredited university. And they suddenly notice it the second time around. Then it'll affect your previous case also, because that's the basis. Your degree is the basis for your qualification. And if you don't have that, you don't qualify under the labor cert. If the labor cert asks for a bachelor's, whether it be EB3 or EB2. So that is rare, but it can happen. I've seen it happen. But most often we have the issue of ability to pay. And that is a very real issue. And again, also because companies file taxes in different ways, based on different issues that they have. They take more expenses or they might have a tax benefit, whatever it might be. Sometimes the profit margin will be lower than previous years, or maybe because of COVID, right? A lot of companies got hit. The business got hit. So it could be that the taxes are not that great this year, and you have to show ability to pay from the date of filing the labor cert to the present. That's a problem. So while the previous year's tax returns don't change, from the time that the I-140 got approved to now, suppose it got approved a year ago or 2 years ago, 2019, they're going to, from the date of the labor, suppose the labor got approved in 2018. 2018 and 2019 tax returns are still the same, nothing has changed, but the ability to pay moving forward after the I-140 approval, which is the 2020, 2021 tax returns. If those are not good, and if your salary is doesn't meet the mark, then your EB3 downgrade can get denied.
So if EB3 I-140 gets denied, will the applicant's previous I-140 EB2 be free?
It's fine. Nothing will happen to the EB2 I-140 as long as there is no issue with the beneficiary's qualifications, as I was saying earlier. If it's just the ability to pay, I doubt that they're going to send. They can if they want to, because again, even for the previous I-140, it has to be ability to pay from the priority date to the date that they get the green card, even after it's approved. So they can still send a notice of intent to revoke if they want to. But it's unlikely that they'll do that for just ability to pay issues. But if there is an issue with their qualifications, which they missed the last time, or some other issue which they missed the last time, then yes, they can send a notice of intent to revoke, and then your previous I-140 can be revoked as well, and then you're left with nothing. So that's something that we want to avoid. So it's important whenever we do an EB2 to EB3 downgrade to do due diligence to make sure that there are no issues, at least known issues, which can come up, and then we advise the clients accordingly, and then based on that they decide whether they want to file the downgrade or not.
How long can you stay on EAD without a job?
So EAD per se doesn't require you to have a particular employer or an employer at any given point of time. For example, you can be on a H4 EAD, L2 EAD. You don't have to have an employer. But in a 485 EAD, that's a slightly different scenario, because if you don't have a job, then who's sponsoring your green card? Unless you file your green card as a future job offer, and you're not working for that employer at all, and you're going to tell USCIS that I will work for the employer once I get my green card, not before. It's possible, but once you have an EAD and you don't start working for them, the question will be, why didn't you have the ability to work for them? You have an EAD. Why are you not working for the employer? Why hasn't he hired you? Does he have the job for you or not? So that's a question that sometimes can be asked. That's why I'm a little wary about future job offers. So also it could be a scenario where there's a gap, right, in the EAD. I mean, in the job. So you're doing AC21, you transfer from one employer to the other, but there's a gap. So will they question that gap, or how much amount of gap is okay? That is not really written in the regulation, but at any given point of time, you have to have some employer that is willing to sponsor your green card, who has agreed to sponsor the green card, be a sponsor for your green card, whether you're working for them or not.
All right. So thank you so much, Ms. Prashanthi, for clarifying all the questions. Viewers, before we wind up, if you have any questions and would like to reach out to Ms. Prashanthi directly, 212-354-1010 in extension is 107, and please email her at prashanthi@reddysq.com. This is Swarna signing off. You're watching Telugu Prajala Manasakshi Sakshi. Namaste.
Namaste.